This week we're going to wrap up part 1 of your textbook. We're going to look at chapter 3 and chapter 4, and there's really a lot to cover from all the different types of lawsuits in the area of corrections and prisoners to actually going to court. Chapter 3 focuses on the civil litigation. This is kind of collectively known as prisoner rights type lawsuits. We're going to cover the concepts of habeas corpus, torts in U.S. Section 1983 actions. Habeas corpus is a Latin term. It means have the body, and it's from the Constitution. Article 1, Section 9 of the U.S. Constitution specifically provides that the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. So a prisoner files a petition asking for the relief, and that relief is focused on the body, the legality of the imprisonment or detention. And usually the relief that's sought is release from that confinement. That's distinguished from some type of complaint where there's a request for damages or injunctive relief. The petition is filed by the individual petitioner. It's against the entity that's holding them in confinement, for example, a prison, and in that case, a warden would be the respondent. If you look back in Appendix 3, I think it's around page 545, it contains a 1997 complaint filed in the U.S. District Court for the District of Columbia. In habeas corpus action, the court will order the respondent, as I was mentioning, example would be a warden, to show cause why a writ of habeas corpus should not issue, or in other words, why petitioner should not be released. And there's a pretty short period of time for response to that. It's ordinarily due within 10 days. There's different types of habeas corpus, and this is probably the hardest thing in the chapter is pronouncing these terms. And really you can kind of look at the core of the word to see what it refers to. Ad subjiciendum is about the subject, and it's intended to review the legality of the confinement, and that's the most common kind in the corrections area. Ad prosequendum, you can kind of see prosecution or prosecutor in there, orders the custodian to bring the party to court for the purposes of prosecution. And ad testificandum, or testify, is ordering the custodian to bring the party to court to give evidence in a court case. So obviously it can be a tongue twister to say these. The point is that if you look at each type of habeas corpus action, you can kind of see in the root of these words what they're referring to. When is there a habeas corpus action? It's the timing's important. It's treated as an emergency. After all, it's challenging the actual holding of a person. And if somebody were held illegally, then there's certainly a lot of other things that can result from that. We've seen lots of lawsuits regarding people who've been confined for years improperly. Following the response by the respondent, the court can dismiss the petition, they can hold a hearing for more information, or they could actually grant the writ. It's not a finding of guilt or innocence. It's just, it's not in that case where we're talking about a civil damages case. So this is statutory. There are provisions in 28 U.S. Section 2241, 2254 regarding these. And there's also the Anti-Terrorism and Effective Death Penalty Act, or AEDPA. This amended the habeas corpus requirements, placing limitations on the use of habeas corpus. More about the AEDPA. Requires an exhaustion of state remedies prior to filing. It allows federal courts to dismiss an application for the writ, even if there's no exhaustion upon finding the writ has no merit. and establishes a 1-year period of limitation for federal prisoners to file a motion attacking the legality of their sentence. You can also use the AEDPA if there's no available state exhaustion procedure, or if the process was such as to be ineffective to protect the rights of the applicant. Now we're going to move on from habeas corpus to torts. Torts is a civil action or a private wrong or injury for which a court will provide a remedy in the form of damages. It always involves a violation of some type of duty owed to that person, whether it's their individual person, their property, some right that they have to the integrity of those things. It's not a breach of contract action. There's 3 elements to torts, and that's a duty, breach, a breach of that duty, and harm. When we talk about that harm or injury, we're looking at whether the actions of the defendant proximately caused the defendant's harm. There are different types of torts. The 2 main categories, intentional versus unintentional, or you may have heard them called negligence. An intentional tort obviously would be a person intending to do something that's wrong. In a negligence case, the person's careless, failed to exercise a degree of care that's required by some statute. An example of negligence in the prison context would be if an inmate's property is unintentionally lost by a prison staff member. There are different types of damages in tort actions. Compensatory, punitive, and nominal are the main ones. Compensatory seeks to recover the actual loss. Could be personal injury, medical bills, lost wages, those type of things. Punitive damages would be to punish the defendant for not just ordinary negligence, but gross negligence, severely bad conduct. Nominal damages basically saying, yes, technically you're right, but there's no actual amount of damages. It's a way of the court acknowledging a tort was done. In the prison setting, we mentioned the example of somebody's property getting lost. Could be a failure to provide medical care, and to a lesser degree, something like assault and battery. And then we've talked about habeas corpus, talked about torts. Now moving on to Section 1983 actions. Again, that's statutory federal law. Often this is referred to as a constitutional tort. It involves injury or harm suffered by a person because of a wrongful action by another. Obviously, we've talked about it a little bit in the prisoner context. Refers to injuries caused by violation of some right that's guaranteed by the Constitution. These are, when we talk about torts in this last section, we're really talking about common law torts. So the Federal Civil Rights Act of 1871 codified in the Title 42 U.S. Section 1983. Since 1960s, it's probably the most frequently used type of lawsuits in correctional litigation. I know that when I was involved in specifically correctional litigation, that was pretty much the major or main thing I was responding to in terms of prisoner lawsuits. Lawsuits under this section allege that some state official acted under the color of state law and deprived a prisoner of their constitutional rights. State prisoners have brought this action in federal court. I know that most of the cases I handled were in federal court. State prisoners who are put away by a state tend to be paranoid about going back into a state court. They often believe that they'll get a more favorable disposition in federal court than state. I know that, and it often depended on what district you were in. Some district courts were more favorable to the corrections department. Others were upset with, and it often went back to some order that the court had entered that the judge felt the prison was not complying with. Most states also have provisions in their state law allowing for suits to be brought for injury that occurs as a result of violations of state constitutional guarantees. Another reason for bringing this type of action in federal court is prisoner can use the ruling in other parts of the country as leverage. So rather than confining it to one state, it would have federal application. And in terms of looking at relief, injunctive relief under Section 1983, there are a couple kinds of injunctions that the text focus on: restrictive and mandatory. In a restrictive injunction, defendants are legally ordered to stop what they're doing. And a mandatory injunction, the defendants are required to do certain things. So it's more of a injunctive relief around stopping something or mandating something to actually happen. There could be damages. However, the prisoner's claim for damages can't be tried or examined under Section 83 if a judgment for the plaintiff would imply that the conviction or sentence was invalid, unless such a conviction or sentence had already been invalidated. And that's Heck versus Humphrey and Edwards versus Balasag. In those cases, habeas corpus would be the appropriate remedy. A person can bring an action under Section 1983 if they feel their constitutional rights were violated. It's brought against some offending official, not necessarily against state or correctional agency. Whoever that person is that they're suing, they need to be operating under what's called color of state law. Defendants are always state employees or officials or somebody who's acting or some type of agent for the state. Again, it only covers state officials. However, which is a little confusing, it's a federal law regarding state actors. There are some cases, Bivens is the big one in the U.S. Supreme Court, that held that federal officials could be sued for violating a person's constitutional rights. Kind of looking at Bivens in more detail, it was a federal narcotics agent acting under a claim of federal authority, enters a petitioner's apartment without a warrant. They search the apartment, arrest petitioner on narcotics, but there's no probable cause. The petitioner sues, alleging a wrongful arrest, asking for money damages from each of the agents. This time, it just wasn't done. The lower courts rule for the government, stating the complaint failed to state a federal cause of action. And the Supreme Court reversed. They said the actions of the federal agents in violation of Fourth Amendment's bar against unreasonable search and seizure was a federally protected interest. Bivens allows a person to sue for constitutional civil rights violations against federal officials in the same manner as Congress allowed such action against state officials in Section 1983. So, a significant aspect of both USC Section 1983 and Bivens, a judgment for the inmate would mean an individual official must pay any monetary award from their own financial resources. The government may still represent them. If they're held liable, they might receive indemnification, which means they're able to turn around and seek money for the liability that they personally receive. But this isn't an automatic thing. Looking at Chapter 4, we're going to kind of walk through the court process, everything from the initial information all the way to the appeal. In terms of how this would apply to you if you're in the corrections field, you might end up being a defendant, you might be a witness in some kind of civil case. Either way, you should treat it seriously, and we'll talk a little bit about how you would appear, act, answer questions in a civil lawsuit. So if you're summoned, a summons is an order by the court to appear. It's usually delivered by civil certified mail or served on an official. And in case the time that you need to respond to complaint, as well as where and how you need to respond, that time is a legal deadline, and that requires an answer or some type of motion. Often it's within 30 days, and the complaint is supposed to be attached to the summons. The complaint says, who's bringing the action, who the plaintiff is, who's being sued, you or the defendants, allegations that are made, statements of fact by the plaintiff, and what relief is being sought. So whether it's injunctive, equitable type relief, or whether it's money damages. There is back on page 545, I mentioned earlier, Appendix 3. While the appendix doesn't have a summons and complaint as an actual example, you kind of get an example of what this process looks like. So I would go back and take a look at that appendix. So getting representation, there's important steps that you need to take as a defendant, retaining all your papers, taking those, envelopes, notes, anything you received in the mail. Don't discuss the complaint with the plaintiff. Do immediately notify your supervisor about the lawsuit that they don't know already. Do get a lawyer. And I'm not just saying that as a lawyer. If I were sued personally, I would definitely want to involve someone who knows a lot about this type of litigation. You usually, if you were a corrections official, would receive some type of information about this in your orientation. Even if you think it's a frivolous, ridiculous lawsuit, you need to get representation. And when you go to see that attorney, take all the paper you've got, any notes you've made, any other relevant information. Maybe it's some type of discipline action or something, documentation. You want to take that. If you're an employee, you're usually represented by a government lawyer, or in some cases some outside counsel that's hired by that agency, and that typically wouldn't cost the defendant money. There are some tricks to this in terms of whether you were acting within the scope of your employment. If you were, then the employee wouldn't have personal liability and the government would take responsibility. But if not, the government's going to say you were acting outside the scope of your employment. And regardless, you're still going to want to have an attorney present. So if you look at figure 4.1, I think it's on page 60, there's a diagram about the scope of employment. So you want to take a look at that. So scope of employment refers to acting in a manner that's consistent with your job, representing the government, and looking at agency philosophy, policy, your job description, orders that are posted, training that you've received. Insurance, certainly you want to act within the scope of an insurance policy. It might be a little jaded, but my impression is insurance companies often collect premiums and then try to figure out how to not pay out. And if it is within the scope of the insurance policy, they're trying to settle in order to avoid the cost of litigation, which can be a good thing. But it could also, if they settle, attract, so the word gets out that they are settling lawsuits and paying money, then there might be other lawsuits that are filed that don't have merit. So kind of taking a step by step through this, there's a complaint and a summons. We talked about that. You get your representation. Always get representation. You take all that information that you have to your legal counsel. Then the answer or motion is filed within that time given in the summons. The answer is the response to the complaint, and then filed in the proper court by the specified deadline. In some cases, I mentioned there could be motions, a motion to dismiss for everything from lack of jurisdiction to improper service to there not being any basis for relief in the claim. But that's not something that you would just decide on your own and not answer. You want an attorney to file a motion for that type of stuff. If that doesn't get dismissed, then the next step is discovery. It's really 4 major kinds of discovery. The first is interrogatories, which are written questions that are submitted to the other side to answer under oath. Depositions are oral questions, again under oath. Somebody is recording your answers. There's not a judge present. The purpose is to kind of tie down that testimony prior to trial. Motions to produce documents from the other side. This, and again, this goes both ways. This isn't just a prisoner seeking the agency's information, but the agency also seeking what evidence, witnesses, etc. In this case, documents that the defendant may be trying to use. Request for admissions, just getting the other side to admit to certain facts to kind of limit the issues that are presented at trial. All types of these discoveries have time deadlines which you have to adhere to. There's usually some order of the court that gives specific times. And failing to do that could result in an upset court, a court that intervenes and possibly orders a default on the case, or get to trial and having that evidence excluded from trial. And discovery is also a process of trying to get the parties to really settle the dispute. So that's kind of, heading to trial, maybe avoiding trial. One way would be a motion for summary judgment, trying to get the case dismissed, basically saying that the party is entitled to win based on an issue of law prior to even going to trial. Obviously, the other side would have an opportunity to respond to that. So some cases are dismissed on summary judgment prior to trial because it's a legal issue, not really a factual claim. The court decides that if they decide to grant the motion, the case is dismissed. If it's not granted, then the case is going to go on. If it is granted, there might be some remedy there in terms of money damages or some kind of injunction. There might be some type of settlement prior to trial. It's not, been my experience, and the data doesn't really reflect it that a lot of these prisoner lawsuits are settled at this point. I would think settlement's less likely in the prison case. Prisoners kind of view this as a win or lose situation. If they actually get some type of remedy, then maybe that will change the agency policy, cause management to do something different, get actual money damages out of it. So they're usually not interested in settling in some cases. A trial, you could have a trial with or without a jury. Employees can be required to testify as witnesses. If you are called to testify, you want to notify your supervisor, contact an attorney. Even if you're not a defendant in a lawsuit, you certainly would want to seek legal counsel. Some basic rules for being a witness. You're going to want to make sure you review your records, reports, everything. Don't memorize your testimony, but be very familiar with what you're going to testify about. dress and act professionally, probably a given, but needs to be said. Remain calm. The judge or jury is observing your demeanor as well as what you say. Take the time to answer questions. No one's rushing you. Try to answer them accurately. Only the questions that you're asked. If you don't understand a question, ask for clarification. Be as brief and to the point. Answer only the question you're asked. If you give a wrong answer, then correct it as soon as possible. It's okay to say that you have discussed your testimony beforehand. Be courteous. If the judge or the attorneys interrupt, then just stop talking and wait for them to let you go on. At the end of all the testimony, the evidence that's introduced, the attorneys will summarize their points, and then it'll go to the judge or to the jury. If it goes to the jury, there'll be some type of instruction that are given after deliberation. If it's a jury trial, there's a verdict. If the defendant wins, the case is dismissed. If the plaintiff wins, there's some type of relief or remedy. And that verdict and damages that are decided becomes an official order or judgment of the court. An appeal could be filed by a losing party. There's a time limit for filing the appeals. Attorneys know those time limits. Either side in the civil case could appeal. The government should provide employees with representation at no cost. The appeal is handled, it's primarily on legal issues through paper. There may be oral argument. The attorneys are arguing this is not a time for evidence to be introduced. They're not reviewing the facts, they're reviewing the law. It could be in an appeal, the lower court's decision is affirmed. It could be that it's reversed or remanded, which means sent back to the lower court. In practice, the right of appeal is up to that first level appeal, the appellate court. Subsequent appeals usually in the federal court system to the U.S. Supreme Court can be requested. Last week we were talking about a writ certiorari, but the court may decide not to hear the case. So this kind of overview of the different types of prisoner lawsuits as well as how a case proceeds through the court system.